And we are hearing from Mr. John Gentry, who is a private citizen. Mr. Gentry, of course, you spoke earlier, but you have 4 minutes to speak on the topic, and then, of course, members may have questions after that. So right, please share with this committee wherever you'd like.
Just really briefly, I want to say thanks to Representative Griffey. Family members absolutely should have, and I hear from people across Tennessee that grandparents want to intervene and take custody, and they have no voice in this process. Very obviously, this bill makes it easier to terminate parental rights and to adopt out children against the will of the biological parents. And my first concern, not provided for anywhere in this bill or in these kind of proceedings, is to terminate parental rights are conducted without the benefit of a trial by jury. The caption for this bill and the explanation by the sponsor appears to be misleading. Looking at Part 1, subparagraph A, it now reads, for purposes of terminating parental rights, abandonment reads, and the old language, and I like to compare these to the old language to see what's being changed. The old language says a parent or guardian is incarcerated at the time of the institution of an action or a proceeding to declare them abandoned. The new language, a parent or guardian is incarcerated at the time of filing. And that's very disturbing. At the time of filing the petition, they're in there. So this changes from incarcerated at the beginning of an action to incarcerated at the time of filing a TPR. What if they're wrongfully incarcerated? What if the judge orders a person into custody for contempt for a couple of days, and then a TPR filing is hastily filed? The worst of this, and we talk about we're tweaking the language here. No, we're adding new stuff. It's in the or section of subparagraph 3, and they added in there, has engaged in conduct prior to incarceration that exhibits a wanton disregard for the welfare of the child. What is wanton disregard? I'll tell you what it is. It's whatever an attorney in a black robe, a guardian ad litem, or Department of Child Services wants it to be. That makes this bill void for vagueness. The vagueness doctrine rests on the due process clauses requiring fair notice of what is punishable and what is not. What may be considered wanton disregard by one person may not be considered the same by another. Subparagraph 25 is changing the definition of a guardian. The old language says a guardian means a person, entity, or a person other than the parent appointed by the court to provide care for the person, their property, or both of a child or adult. The new language says much the same, but it says, and authorized by the court to adopt or consent to the adoption of the child as a result of surrender or termination of parental rights. So now, I mean, at least take out the and change it to or. Because the way this is written right now, to be a guardian, you have to be authorized by the court to adopt or consent or consent to the adoption. Here's what I want the body to understand. Very obviously, the bill makes it easier to terminate parental rights and adopt out children. It appears to me that the intent of this bill is for the state to more easily obtain Title IV federal incentive money and for attorneys to make more money off of these types of cases, and not so much to protect the welfare of the children. This statute has been amended once in 10 years between 1951 and 1961, 4 times between 72 and 83, 6 times between 1990 and 2000, and 8 times since 2001.
Thank you, Mr. Gentry. I apologize. That did exhaust your 4 minutes. But again, if members have questions for you, we can take as much time as you like. So, members, do you have any questions for Mr. Gentry? Representative Mitchell, you're recognized.
Mr. Chairman, I'm sorry. I'd just like to hear the continuation of his facts there. Let's give him 30 seconds.
Representative Mitchell, the witness was notified of the 4-minute time limit, but if you have a specific question, I'm sure he would be happy to answer it.
Yeah, could you tell me how many times this bill has been amended from 2001 until now, and other facts regarding this piece of legislation?
So the last one was 6 times between 1990 and 2000, and then 8 times again since 2001. And the fact that this statute has been amended so many times over the years is evidence of a continued tweaking, suggesting pretended legislation for improper purpose. If the legislature wants to keep changing statutes...
Mr. Gentry, I believe you answered the member's question. And next on the list, I have Representative Towns. Representative Towns, you recognize?
Mr. Chairman, thank you, sir. And Mr. Gentry, if you don't mind, would you explain a little bit as it relates to the Title IV incentive money, and how does this play into the increase of that?
So,
Mr. Gentry, you recognize?
Sir, child support payments that are enforced by the court, as well as the foster care system, when a child is taken into custody by the state government applies to the federal government for Title IV incentive dollars, which is the Social Security money for all of our retired people. And so they're pulling that money out, and they are incentivized to wrongfully take children in many cases. And I hear instances where they will take custody of a child because they couldn't afford to pay their electric bill and got their lights turned off one time, and their neighbor, was being a jerk and called in Child Protective Services on them. And I can go through a list of stuff they make up. And it's not just children, it's also the elderly. And you notice in this bill they talk about elder care. And so one of the common themes that you hear from this is an elderly person who is self-sufficient, living alone. They go into the hospital for a bed sore. And then the state's like, oh, well, gosh, you can't take care of yourself anymore. And so we're going to appoint a guardian ad litem. And then that guardian ad litem will start selling off the assets of that elderly person to pay for his fees as well as to pay for the nursing home. And
excuse me, Mr. Gentry, I think we may have switched topics. I think we're talking about conservatorships now.
But it's very similar with this termination of parental rights. The state is absolutely incentivized to take these children under color of law, very often on false and unsupported allegations. And the parents, very often they target economically disadvantaged people for this. And here, with the language in this bill about how, let's see, what was it? The wanton disregard. That is totally new language that they're using.
To be clear, wanton disregard is already a term that's defined in the code.
Okay, well,
it's in the current statute.
I downloaded the entire statute for 36, whatever, let's see, 36.1.102. I downloaded the entire thing, and I didn't see a definition in there. Maybe I missed it, but I looked pretty carefully. Did that answer your question, Representative Towns?
It did, sir. Thank you, Mr. Chairman.
Okay, I see no one else. Oh, Representative Mitchell, you recognize?
Yeah, question on the bill, please.
I'm sorry, Representative Mitchell, we're out of session at the moment. But I'd be happy to recognize you as soon as we go back in session. Representative Parkinson, I had you on the list.
Thank you, Mr. Chair. And thank you for your testimony. What would be a better way of doing this? What's the solution?
Mr. Gentry, you recognize?
Trial, definitely trial by jury. We cannot trust these attorneys in black robes and the guardian ad litems who are attorneys. They are acting for their benefit in these cases, and the best thing to do, whenever there's a fundamental liberty interest at stake, there should always be trial by jury. In criminal cases, we have trial by jury mandatory. Whenever there's a fundamental liberty interest from taking somebody's arms under the Second Amendment or depriving them of a God-given right to parent their children, they should have the benefit of a trial by jury. And it's denied in these type of cases, and they are never advised of their right to a trial by jury. We have a right to a trial by jury. It's in Rule 38 of the Tennessee Rules of Civil Procedure, but people never know about it. And the guardian ad litems don't tell them that they have a right to a trial by jury.
Representative Parkinson, you're recognized for follow-up.
Thank you, Mr. Chair. Is there a change in the definition of abandonment under this new legislation?
I did not approach it looking
Mr. Gentry, you're recognized.
No, excuse me. I did not approach it looking at the definition of abandonment in here. But overall, when you look at this and say, now for wanton disregard, and you look at it when they're changing who a guardian is, having to be authorized by a court to adopt or consent to the adoption, I'd say, yeah, it's changing the definition of abandonment here.
Last question, Mr. Chair.
Representative Parkinson, you're recognized.
Thank you, Mr. Chair. Is the term wanton? What was the term that they use? I'm sorry.
Wanton disregard.
Okay, wanton disregard. Is that used in the previous legislation also, or is it only used in this new version of it?
I printed off the entire, what I do when I analyze these statutes and propose bills is I go take the original language and then I block in and I mark out what the old language was, and then I insert the new language, and I'm like, okay, what are they trying to do here? And that clause about wanton disregard is absolutely new language in the bill from what I see.
Okay. Thank you, Mr. Chair.
Thank you, Representative Parkinson. Members, if no more questions for Mr. Gentry, thank you very much, Mr. Gentry, and we will go back into session. We are back in session. Just remind everybody of our posture. We are on House Bill 1676 by Chairman Carter. There are no amendments. We have a motion and a second on the bill. We've had extensive questioning.
Call question.
I would recognize Representative Garrett to call the question. Question's been called. All those in favor of sending House Bill 1676 to calendar and rules, please signify by saying aye. Aye. Those opposed? No. The ayes have it. Calendar and rules, sir. And I apologize. Representative Howell, you had asked to be recognized to speak, and I believe I passed over you. So, Representative Howell, you're recognized.
Thank you, Mr. Chairman, and that's okay. I just had a comment. I didn't have a question. I just had a comment about the proceedings that we just experienced.
Yes, sir. You're recognized.
Okay. I think for a witness to suggest that we pass adoption legislation up here in this legislative body to benefit lawyers or so the state can benefit from federal dollars is outrageous. And that's what we heard. It would also have been helpful if the witness would have disclosed that he is running for elective office to be elected to this body. So, take that with a grain of salt.
Thank you, Chairman Howell.